Lanka. Welcome to another episode of Law and Order, where we talk about current affairs that affect all of us in certain ways and to give you all a legal perspective towards it. And we're going to talk about an interesting topic today because what we have seen over the last year or so with the pandemic and the issues it has had on employment. We're going to talk about EPF, or Employees Provident Fund. And to do so, we have with us on the studios today Mr. Rajiv Amarsurya, attorney at law, who is also the incumbent secretary of the Bar Association. Good evening to you, sir.
Good evening, Ishan. Nice to be here on the show.
Welcome. Let's start off by looking at what is employment and what's the legislation behind it in Sri Lanka.
Yes, that's an important question to start off this discussion. Actually, we refer to it as sometimes a master and servant relationship. This is something which became more important after the Industrial Revolution. And then there was a need. This was because the master or the employer was at a higher bargaining position, in a stronger position than the employee. So then, of course, we had the trade unions, the formation of trade unions. Then there was laws which were brought about across the world, in different contexts. And of course, then there were tribunals and courts. And so that is how this employer-employee relationship commenced. And with time, sometimes we call this legislation social legislation, because this is to put right unequal, or you can say unequal playing field, or a balance which needs to be put together. So that is how it commenced across the world. And then we have several pieces of legislation. We have the Industrial Disputes Act, we had Factories Ordinance, we have the Shop and Office Employees Act, we have Wages Boards Ordinance, then we have Employment of Women, Young Persons Ordinance. Then of course we have the EPF Act, which we'll be speaking about today. We have the Employees Trust Fund Act, we have Payment of Gratuity. So there are a number of pieces of legislation which are in place, which protect the employee, and also provides a mechanism for the employers also to know where this is the framework, these are the parameters within which one has to work and operate. Then also I think one part of your question would be, there are several types of employees also. There are permanent employees, there are casual employees, temporary employees, seasonal employees. So the problem sometimes arise when the line between these various types are a little blurred, and sometimes you have characteristics of one and the other mixing, then you have problems, and then you need to resolve as to what category one falls within.
Right. So you mentioned about various aspects of the law and the legislation in the country and all of that, where employee or employer, the most important part of it is the contract. So how does the law affect when it comes to employment of contract or employment for contract?
That's an important distinction, and that is an important distinction in law. Employment of contract is basically the employer-employee relationship which we know of. Now, you might work for a organization. You work from 8 to 5. You are an employee. You are under a contract. It can be a written contract. It could be a verbal contract, or it could be by implicit contract. So that is that is generally what we refer to as this contract of employment. Then contract for employment is what we refer to as independent contractors. They are people who don't work for you. They will come and perform some work, but they are their own employers. So the distinction is important because much of the legislation, or all the legislation, deal with the first group we just spoke of. They are the employees in common parlance. So there are clear examples. Now, for example, I said 8 to 5, someone works for a year or 2 years and you're working, you're an employee. But there are instances where, and then you might have an independent contractor. For example, you have an office and you want to maybe do an extension. Somebody comes and does that for you. So that you pay a sum, they will and perform that work. So that is a clear demarcation. But then as we get closer, there are situations where there is a mix of the two. So the law has developed certain tests to identify who is a employee under the contract of employment and who is an independent contractor. So the test, the initial test was this control test. Who the control of the way the work is done. Now, say you are working in office, your superior will tell you, well, this is how work has to be done. This is how you have to report. These are your times. So that is the control test. Independent contractor, again back to my example, say someone, say you're say renovating something, somebody comes and is doing some work for you. You will give the contract over to him, but you won't tell him, well, this is the way you nail this place, you don't give those specific instructions. So that is the control test. Then there is the economic reality test. That is, what is the economic reality? Is the person dependent upon you for the income? So that is that example I said. But the independent contractor is not. This is just a job, finish and go, and they go somewhere else. Maybe they do parallelly several things. Then there is another test, the integration test. The person in question, is that person an integral component of your operation? Now, the employee we spoke about, that 8 to 5 employee, is an integral part of your operation. Maybe he holds a senior position, maybe he holds a small, but he is part of that setup. But the independent contractor is not. He comes, he will do his work and go. And the law is further developed. This is not something the recent is some many years back. The mixed test, the multiple. So that is actually what is now taken cognizance of, because employee-employee relations are a little complex in the modern world. Long years ago, you work for a factory, or a factory operator, or a factory supervisor. Here the work is a little different now, and also with this COVID, it's more complicated. Now people sometimes work from home. And so how do you determine whether you're an employee or an independent contractor? So the mixed test deals with all these characteristics. And so it will basically, so if there's a dispute, say you're in court and you want to determine whether you're an employee or independent contractor, you will look at all your characteristics, from the payment of your salary, whether you get a commission, whether you have given a deposit, security deposit, whether your time, whether your employment is, are there fixed times, do you sign an attendance register, do they give you uniforms, is there a disciplinary process? And so everything will be considered to see whether you fit into the grouping of a contract of employment or an independent contract. Another thing which is important here, Ishan, is that sometimes now, as we said, the governing criteria is that the employer is at a higher or stronger bargaining position than the employee. That's reality. So sometimes you might have a situation where the employer, in the contract of employment which you sign, might say, well, you are not an employee, you are an independent contractor. And because you need that job or the work, you will sign it. Sometimes you might not even read. In Sri Lanka, a problem we have is people sign documents without reading. I mean, so you might sign it. So you may not, one option is you may not have seen. The other option is maybe you have seen, but at that point of time, you will just take anything they offer. And so that the courts do not go by what is said in the contract. There is not a presumption, but there is appreciation of the fact that that contract may not have been entered into on an even footing. And so that is something. So that is why they fall back on what are the characteristics of your employment. So that is important. Now I mentioned a series of legislation. So it is a contract of employment, or employee in that common sense, common parlance, who would be entitled to those benefits and the protections. An independent contractor is someone who is not. So that distinction becomes important across the board.
All right. So that's a clear indication of what employment, of contract and for contract. I'm going to move into the topic at hand, Rajiv, to look at what is Employees Provident Fund, or EPF as we very commonly call.
Employees Provident Fund is a scheme which is there, which will give you a sum once you retire. Now in the government, now if you are a public servant, say you are a department employee or a ministry employee, you would be entitled to a pension. That is because you have a retirement age of 55 or 60, and that is considered the period in which you are most productive. And thereafter, if you have not consciously saved, you will not have income thereafter, and it happens to a lot of people. And so there are various schemes in place to give you some kind of income thereafter. This is also to some extent a forced saving, which is by statute. Now, if you have entitled to a pension, then if you are a government employee, you know you will get a certain amount of your salary every month. It will reach your bank account, and you have no fear because this is the government which is paying you. So we assume that the government will continue to pay. Now, the Employment Provident Fund was a scheme which was established by the state, by statute, to ensure that this similar scheme, a pension of course you will get every month, but at least at the point of retirement, you will get a lump sum, a sum to your hand, which you can then, if you are prudent, you will probably invest it in some way, or buy something which will give you a continuous some kind of return. So the Employment Provident Fund generally applies, it's a little technical, but generally applies to employees in the private sector. Let's look at it the other way. It doesn't apply to government department employees, local authorities, local government, and there are certain categories of employees, or not employees, certain category of persons to which EPF won't apply. For example, if you are a director of a company, say you are a partner of a firm, you are in a different category. Again, you go back to that test we talked about, employee. So then you won't be an employee in the traditional sense. And there are certain other groupings. So say if you are employed in a residence as say a domestic employment in the residence, then you won't. It has been excluded. So apart from that, and also the regulations have set out for certain industries a minimum number of employees needed to operate this. So sometimes 1, 3 is very small numbers, but generally, if you are working in the private sector, you would be entitled to this in the scheme of EPF. The collection and payment, I think we'll discuss as we go on. But you'll fall into the category of an employee who is entitled to we can even say protection, because that is a benefit. Because sometimes what happens is when you are working, I mean, how many of us save? What we earn, you have expenses. I mean, it's only a few people who consciously say, okay, I'm going to keep 20% of my income for saving, because sometimes that 20% you need. I mean, it's not everyone doesn't have the comfort of having a extra, but this is a forced saving by law.
So, Raj, you mentioned about who falls into the category of EPF and who does not.
Yes.
So, in the case of, as you mentioned, a director of a firm, let's for instance say he's been working in the firm for 20 years or so, through maybe DGM or GM level, and then get
I need to clarify.
Yes.
When I said director, again, so this is why this what we started off employee. Well, that is not independent contractor, but you are an employee. So there are different types of directors. Now there are non-executive directors on boards who will come for a meeting, who will get the board fees and go, and they will see them maybe at an audit committee next time, then again the next month or 2 months later the board meeting. So those are the directors who would not get. But there are other directors now in companies who are actually employees. As you said, you have started off as a management trainee, you will get promoted as a manager, senior manager, AGM, DGM, and then you sometimes are invited to the board as a full-time employee. So that gentleman or lady would actually be going to office from 8 to 5 or maybe flexi hours, but working, and so they would be entitled to EPF, but not the lady or the gentleman who would come in for a board meeting and then go out.
So looking at all of this, Rajiv, EPF, is there a stipulated rate at which an employer should pay, or they can decide on their own?
No, how it works is there is a standard minimum payment. The employer must contribute 12% of the total salary or the total payment. The employee must contribute 8%. And so ultimately 20% gets remitted to the EPF account. EPF also, there are certain, it's managed to the central bank. They also invest it. So there is a return on that as well. And it is expected that the money will grow.
And looking at that particular aspect, something that we've always thought about is that what if an employer deducts the amount but does not pay to the fund.
No, that's a serious, that's offense in terms of the law. So actually this is where the employers also must be very conscious of this, because the law provides for the employer and the employee to contribute certain percentage. If something doesn't happen as it should, because again you go back to the concept of the employer being in a better position. So the responsibility, liability all transfers to the employer. So if say there could be several instances. One is where what you mentioned, the employer collects but doesn't, that of course is bad faith. So that there is an offense, and then anyway you'll be liable, and anyway they'll have to pay. So ultimately when it surfaces, the employer is responsible, quite apart from the fact that you would probably trigger an offense, would be liable to pay plus a surcharge. Surcharges can go up to 50%. Now there could be also a situation where you don't collect from the employee. Now this is where sometimes you have situations, and I have seen this in several cases, where the employee is also happy not to contribute. Why reduce? You are looking at your situation in the present. The government has thought of you, from a policy point of view, that 20 years. But if you can keep that amount also with you, that because you also have to contribute. Sometimes there may be situations where even the employee doesn't really mind now. But if that happens also in the law, when it gets surfaced and the employee at some point complains, then that is the responsibility of the employer. So the employee will have to pay not only his 12%, also the 8% plus a surcharge. So then of course it goes beyond. Now the process is that I think we might discuss it as we go, but so the liability is very serious, and this sometimes has been a big issue in situations where if you have 1 or 2 employees you can manage. But I know examples of, for example, employers who were, say, doing big business, maybe apparel and like that. We have 200-300 employees, and for some reason they had different arrangements, not gone through this. At some point when this amount of what you need to pay is determined, it's a huge amount. And sometimes if you have gone, your business is not doing too well, you may not have those funds. Then what happens? And then whoever you are, at whatever level you are, if you can't satisfy the debt, then they will imprison you. So on a matter like this, you can end up in jail.
So Rajiv, looking at all of it now with what you have just mentioned, say in the case, say, can an employer give employment to an employee without agreeing on EPF?
No, this is a statutory liability. There are instances where sometimes you find contracts where you say that is a very dangerous practice. One is that it's a statutory liability. There is it does not provide for some kind of waiver of the right, because it is due in terms of the law, and assuming even if you just let's assume that it happens, then when sometime later the employee gets up and says, no, there was this unequal bargaining, I didn't know what I was doing, they got me to sign, then what do you do? And so it is a very dangerous, it's not countenanced in law, it's not something which should be done, and actually the payment of EPF is not a very serious matter. Just that when you get you hire an employee, you have to factor in your EPF liability also. Sometimes what happens is you think, well, I have an additional burden. No, as an employer you decide, okay, this is how much I can pay to X. That must, when you make that determination, you must also factor in the EPF. Then you are protected. The employee has less, because then they have to, that's by law. So it's not so sometimes you think of EPF as additional burden. It's not. You work out what you pay, and then that is something anyway you are paying. This is not something the state is, you are anyway paying this to the employee in the form of EPF, which the employee can collect at a later point of time. So it's the best situation is to actually go ahead and pay. The only problem is there is some administrative work you have to do. But the problem is when you wait years and months and later it becomes an issue, then the sum is much larger. Here, just every month you pay some amount.
That is true. And one more thing that I want clarity on, Rajiv, is that people change jobs. Are they able to claim whatever EPF that's been collected, or is it only after they reach their retirement?
Yeah, there are some certain workings within the EPF how they allow disbursement. Generally, the practice is if you have an account, then the next if you go into another employment, then that account it will connect, and this money will go. But there are certain situations in which you can take your EPF back. There is an age. I'm not exactly sure what I think 50 or 55, but there is a point. Also, for example, if you are a lady and you have maybe decided to stop working, there are situations where you can. Then if, for example, you are going to migrate abroad, so those are administrative. I mean, as lawyers, we don't get involved in that part of it. But there are administrative provisions under which you can withdraw. But the general principle being that you need to keep it till you finish working, till your work retirement is reached. That the principle is that. But if you allow members to withdraw early, then the whole purpose of the EPF Act is lost. But I think I have heard that there are also schemes where you can maybe take loans against the balance you have in the EPF.
There is a certain percentage that
percentage
you
where you can take a loan, but
as a loan.
Yes. So the money will retain.
So it's accounted up to about 80% of what's already collected in your EPF account. You could actually take a loan. That's under the legislation right now. You mentioned about going abroad, but I'd like to ask you a question with regards to foreigners coming to Sri Lanka and working in Sri Lanka. Are they also part of EPF?
Because a foreigner, if you come in and work here within our legal framework, you become an employee in Sri Lanka. Unless, of course, if that foreigner is entitled to a provident fund scheme, maybe for example, if it's a group of companies and you have come in for a short time, but if he is entitled to a provident fund which is greater or better than what you have here, then of course you will be justifying he is entitled to that. You are not entitled to several. It's one provident fund. Also, I think what we could mention is that there are institutions which are permitted to have private provident funds. That has to be either in these percentages or better, but that has to be approved. So, but if a foreigner just comes and works here with a residence work permit and works, then he also is subject to or he is entitled to EPF.
So, Rajiv, say you mentioned about this is a statutory requirement in the country legislation. The government has decided that the private sector should have something at the time of retirement because there is no pension for them. And this is a scheme that the government came up, and it's there and it's only available at the time of retirement with a few exceptions that you have. But in the case if something of a dispute comes up, where can an employee go and complain to?
Yes, and disputes do come up because sometimes there are instances where, as we mentioned before, you mentioned it was not collected or it was not paid, and then of course you have to complain. You can go before the Commission of Labour and make a complaint. The employee can make a complaint, and there is a inquiry which they will hold. They will hear the employer, and they will come to a determination. Now, that determination, so then what they will do is then they will issue something called a final notice to pay this certain whatever they decide, and then that would, and in the event of that final notice, first there will be a notice, then there will be final notice. If that is not paid by the employer, then they have various enforcement mechanisms, go to the district court and likewise, but what they usually use is to go before the magistrate's court, and they will place the certificate before the magistrate. The magistrate can show cause the employer, but it's only a limited show cause which you can provide. For example, that you have paid it, that the court or the court doesn't have jurisdiction and things, a few defenses, but otherwise the magistrate could impose it as a fine. So, if it's not so as a fine which will be transferred, so in the event that you don't pay the fine, then the employer could even be, or the directors of the company could be imprisoned. So there is it's a very serious matter. Another thing I want to say, is those are the black and white situation. But also with now with development of the way we do things, there are categories of persons who don't traditionally fit this employee classification. But and now, for example, you have outsourced employees. You have people who work on there are institutions who give them on targets. For example, a lot of companies now take sales reps who the employer doesn't consider employee, and they say, okay, we come, we give you do this for this. If you or even sometimes recovery of debts, you give certain incentives. So if you do this so many, we will give you so much. We pay you a commission. Now there are situations where those arrangements in the mind of the employer, sometimes it is arrangement where you are not employed, but sometimes once you give that role, you start giving certain tasks and functions and giving them recognition to what an employee would have. So then you have situations where those who you don't consider your employees, then saying later on, well, no, actually we have all the those characteristics of an employee, and then they go and they sometimes make a claim for EPF, ETF, and so then of course the liability is much more. So
all right, quite interesting as to what really could be done. We've come to an end of the show, and I got to thank Rajiv Amrasuri for being with us and sharing his expertise on a very timely topic with all that has happened around the country and what we hear with employment being terminated and all of that over the pandemic and all of that we have gone through the last year or so. We will talk about ETF, Employees Trust Fund, and gratuity next week on the show as well. It's time for us to say goodbye on Law and Order. See you next week. Bye-bye from us.